flip from North Broward to the main jail.
Okay. On the North Broward, I want to go to the main jail.
Yes, Your Honor.
How do I flip?
On the bottom,
Oh, main jail, here we
main
go.
jail. There you go, Your
there he
Honor.
is.
You're
Okay.
good to go.
I think we're ready.
Yes, you are.
Okay, State, are you ready?
State's ready to proceed, Your Honor.
Okay, we're here in the interest of Todd Edward Watson.
Judge, he's here present at Maine. I believe the public defenders was one filing the case we withdrew, and Mr. Watson's representing himself pro se. I don't know if you wish to inquire.
Mr. Watson, have you chosen to represent yourself, sir?
Yes, Judge.
You understand that you take that at your own peril,
Yes, sir.
that there are a number of charges that are being alleged against you.
Yes, I do.
You understand you have the right to have an attorney, sir?
Yes, I do, Judge.
That the Constitution allows you to have a court-appointed attorney if you cannot afford one, sir?
Yes, I understand that.
Is it your choice to proceed without an attorney, even though the court has the ability to appoint an attorney for you, sir?
Yes, Judge.
Have you thought about having an attorney on a standby basis in case you needed to consult somebody concerning any of these charges or the proceedings as we go along?
Yes, Your Honor, I have, and I have actually put in a motion for that. I put in several motions, actually. Unfortunately, Judge Sloan, who was the misdemeanor judge, has possession of those, and now that felony charges have been filed, I guess they're going to be bumped up to whatever felony judge has been assigned to the case.
Correct, but you still have the right to have an attorney appointed, or have, if you choose to represent yourself, you still have the option of having an attorney appointed to be a standby attorney in the event you needed someone you could consult with, sir.
Correct. I requested a shadow counsel in the motion.
Now, it's my understanding the public defender withdrew previously, is that correct?
That is correct, Judge. So I believe it, therefore, if there, since there was an order entered withdrawing, relying, I don't have the specific motion in front of us. I believe it was due to a conflict. Then I don't know if Your Honor wishes to go ahead and explore the option of regional counsel at this time.
I did review the motion, Judge, and
Yes,
we
sir.
did withdraw due to, I guess, for lack of a better phrase, irreconcilable differences.
Okay, did the previous judge appoint
As far
regional
as,
counsel or conflict
So
counsel?
it's my understanding, Your Honor, that after this court handled the original first appearance for the misdemeanors, it appeared in front of Judge Slum as county court judge appointed by the Supreme Court to handle the case at the time when it was misdemeanors.
Yes, sir.
It's also my understanding, although I haven't seen the transcript of it, that there was some form of a Ferretta hearing conducted at the time by Judge Slum, allowing Mr. Watson to represent himself, which all occurred prior to the state attorney's office for Miami-Dade County being appointed. Once we were appointed, we appeared last week and we filed the new information charging the 4 felony counts plus the additional misdemeanors. But at the same time, unfortunately, because of the felonies, Judge Slum was divested of jurisdiction. Because at that same time, the state had requested a psychiatric examination of Mr. Watson. The state's going to request another psychiatric examination of Mr. Watson. We believe that based upon the actions that he's taken, we believe that the material that's been read and reviewed and that I've heard, and conversations we've had with people who are friendly with him, he is delusional, among other things. In that situation, we don't think he's competent to proceed to court, to trial, or for a hearing, and therefore, it's our opinion he cannot represent himself because he's not competent to proceed to trial as a defendant. How could he be competent to represent himself? So it would be our request that an attorney be appointed to represent him. Maybe not necessarily today, but somebody would have to be appointed to represent him when he appears before the circuit court judge, who I believe is Judge David Tunis, who will be taking over.
Understood.
Your Honor, if I may, I have defended myself in litigation. I was resentenced the day before I was supposed to be scheduled to be released, and to 30 years, and I fought that and I won. I have litigated on my own. I have had an evaluation, and not only was I deemed competent, I was deemed highly intelligent. So And it's funny because the state is alleging, you know, whatever they're alleging, that I may be incompetent, yet no one has disputed any of the facts that I have put forth of all the crimes that have been committed because of all the evidence that I have put forth. So, you know, I have a real problem with actually what's going on here, sir, but I am very competent to represent myself.
Well, in abundance of caution, you know the old saying, you know, about a fool representing himself, having being his own lawyer. I understand that you may have had that in the past, but it seems to me in abundance of caution, I would appoint conflict counsel at this point, based on where we are today, the new beginning of this new charges, or added charges as the case may be. And you can bring up the other issues at a time when the judge is going to be handling these cases in the long term. You'll have a chance to appear before that judge at some time in the future and can raise these issues. But it seems to me, in abundance of caution, the court would appoint conflict counsel at this time to either represent you, if you choose to have them represent you, or at least be shadow or standby attorney if the court feels that you are capable of representing yourself at that point.
Judge Sloan already had the Feretta hearing, and he deemed that I was capable of representing myself, sir. So I understand the charges that are pending before me. The misdemeanor charges have not been filed yet because they're basically wholly frivolous. Now they have these, second degree extortion charges that, have no merit. So, I would really like the opportunity, like I say, Judge Sloan ruled that I am competent to represent myself. So if you assign a conflict-free attorney, then, we're in a situation where I am being illegally detained right now because the other charges have not been filed and a magistrate hasn't been, performed. So where do we
Well, I
stand
think we're
there?
here today to do that.
Your
Is
Honor,
that
just-
correct, sir?
Okay.
Yes, to correct Mr. Watson, who is not an attorney, the information was filed last week. That included 4 felonies and, I believe it's 15. I have to check my number. I'm sorry, my math isn't great. That included 4 felonies and 13 misdemeanors. So those are filed. He is incorrect. The charges have been filed. They are pending against him. They were filed last week. So those misdemeanors are there and the felonies are there.
No, I'm talking about the original misdemeanors that I was charged with, were never filed. So you're not correcting me.
Well, it seems like they filed a new information which would supersede whatever those prior charges may have been back
There was no
then.
prior information, Your Honor. What happened was, when he was charged by arrest affidavit. Therefore, when the state reviewed it, we made a determination to file the information, which included the felonies and the misdemeanors, and whatever misdemeanors we did not charge were not charged. This is what he's facing right now, 17 counts, 4 felonies, and the rest are misdemeanors.
Given where we are, Mr. Watson, again, you've been through a Feretta hearing. You understand the nature of these charges that have been, you've got a copy of the information or the charges, sir?
Yes, I do, Judge.
Okay, there's 17 total, 4 felonies and 13 misdemeanor charges. You understand that?
Yes, I do, Judge.
Okay, you believe that, based on everything you've been through and the hearing that you had before Judge Slom, that you feel capable of proceeding and handling this yourself?
Yes, with shadow counsel, I do, yes.
Okay, you understand the risk inherent in representing yourself in a case like this?
Yes, I do.
You understand the potential consequences of handling something like this on your own?
Yes, I do.
And the potential consequences of either a judge or a jury not agreeing with your perception of the case, sir?
Yes, I do.
And that you could be facing incarceration depending on the outcome of this case?
Yes, I do, Judge.
All right.
Now, having said all that, Your Honor, the state is still moving pursuant to Rule 3.210 for an examination of this person to determine whether or not he's competent to proceed. The rule says that if at any material stage of a criminal proceeding, the court of its own motion or on motion of counsel for the defendant, well, he's certainly not gonna move himself to have himself examined, or for the state, has reasonable ground to believe that the defendant is not mentally competent to proceed, the court shall immediately enter its order setting a time for hearing to determine the defendant's mental condition. We are raising that issue pursuant to the rule. We think he's not competent. We would like to have doctors examine him, which again goes back to my point. I don't know how he can represent himself if he's not gonna be competent to stand trial, potentially.
And what are you basing this on?
Your Honor, it is,
What is this being based on? It's being based on information that you read in my motions?
state does not
What-
speak to defendants, Your Honor.
Okay, understood.
Well, I'm asking the judge, what is the state basing this on?
Have you
Because once
filed,
again-
excuse me, sir, have you filed the
Yes.
actual motion?
I have filed a written motion. I raised it the last time we were in front of Judge Slom, and I'm raising it again now. It doesn't require it necessarily to be in writing as long as it's raised pursuant to the rule. We've raised it now, and again, if there's something that can't be done now, I'll have to raise it again in front of Judge Tunis.
Okay. Well, for purposes of this hearing today, I'll find that you understand the nature and consequences of what's going on here and the charges against you, that you have insisted on representing yourself in this case. Given the circumstances, in an abundance of caution, I'm going to appoint conflict counsel to act as shadow counsel for you at this time. Do you want to run through the charges, counsel?
Yes, Your Honor, the defendant has had an information charge filed against him. Information, therefore, based upon the law of the state of Florida with the filing of an information, there is probable cause has been found because of the filing of the information to determine that the defendant has committed 4 counts of extortion by contacting, do you want me to go through each and every defendant, each and every victim?
I think so, right at this
Okay.
point, yes, sir.
As to count 1, the defendant is charged with the extortion of Judge Jeffrey Levinson. On May the 11th, 2017. In count 2, he is charged with the extortion of Judge Edward Merrigan on May the 17th, 2017. In count 3, he's charged on May the 18th, between May 18th, 2017 and May 19th, with the extortion of the clerk of the circuit court, Brenda Foreman, which may create another issue down the line. Count 4, he is charged with the extortion of Denise Goldsmith, who is a judicial assistant in Broward County. All of these are threatening calls with the intent to extort by threatening to do either serious harm or with the intent to compel that person to do any act, and the acts are laid forward. In the count 1, the act he's alleged is to get a ruling against him or for him in a court proceeding. Count 2, the act is for that judge to recuse himself or rule on a court filing. Count 3, the act would be trying to force that clerk to expedite a motion. Count 4, to force a judge to call him back or have his motions ruled upon. Count 5 is based upon the fact that willfully, maliciously, and repeatedly follow, harass, or cyberstalk Judge Jeffrey Levinson. Count 6 is the same charge as it relates to Judge Edward Merrigan. Count 7, same counts relating to Judge Kenneth Gillespie. Count 8 relates to Judge David Hames. Count 9 relates to Judge Peter Weinstein. Count 10, the defendant is charged, starting in count 10, with obscene and harassing phone calls. And in count 10, it's a call to Judge Andrew Siegel. Count 11 to Judge Martin Fine. Count 12, Judge Ernest Culra Jr. Count 13, Judge Peter Weinstein. Count 14, Judge Edward Merrigan. Count 15, Judge Timothy Bailey. Count 16, Judge Andrew Siegel. Count 17, Judge John Bowman. And Your Honor, the information having been filed, those are the counts. The state also knows that this court had sat in the original first appearance in this matter for the defendant when he had his bond came up on the misdemeanors. And at that point, this court issued specific orders And those orders included stayaways, refraining from contact of anyone other than a family member or his attorney. At the last time we appeared in court, it was raised by the state that the defendant did call and contact a Sheldon Glauser, Glauser, who the defendant admitted in open court in front of me and on the record that that's the person he did contact, not a family member or an attorney, as this court had stipulated, and because Mr. Glauser may or may not become a defense witness for him in that situation. That means that he violated this court's previous order that you had entered on, I believe it's the 18th of July, where it specifically said, okay,
Your Honor, if I may briefly, I became.
I'm not finished, Your Honor, I'm not
Let him
finished.
finish, sir, first. Okay.
See, I'm trying to get the exact copy of the order. Further order of this court, the defendant shall only be allowed to communicate via phone, mail, or in-person visitation with his attorney of record or agents of his trial attorneys or with his family members. By his own admission, Mr. Glauser is neither a family member nor his attorney because he doesn't have an attorney at this point. Therefore, by his own admission, he has violated the court's order. Unfortunately, I'm in a strange position. Normally, I'd ask the court to potentially think about holding him in contempt and raise his bond. But it's hard for me to do that when I don't think he's competent to proceed. And if he's not competent to proceed, then he wasn't competent to understand this court's order. The state's in a very interesting position. And I candidly tell you that. So, as a result, even though we're not asking the court to have him held in contempt for violating your order, what we are saying is he's got 4 felony counts. The prior bond, I think, totaled out to about $100,000, if I'm correct. We are going to ask the court to add an additional $25,000 per count for the first 4 felonies, so that he would be having potential. And I think we'd have to go backwards again because of the other counts, but we'd ask for $25,000 per count for each of the 4 felonies and $10,000 per count for the remaining misdemeanors. And that would be 13, so that would be $230,000 is what we're asking for as a bond.
Okay. Mr. Watson, I'm reminding you that anything that you say, this is on a tape, can be used against you in any upcoming hearing. At this point, you understand that, sir?
Yes, I do, Judge.
Okay. You have an opportunity to respond if you choose to, or you
Yes.
can stand moot to the charges. It's your choice at this point.
Absolutely not. I want to respond to this.
Okay, sir?
Can I go ahead?
Yes, sir?
Okay, first, these proceedings are a total fraud on the court. On July 24th, 2017, this document was filed with the clerk of the court in regards to the instant case. It's dated July 18th, 2017, the day of my arrest. It's titled Notice of Defendant's Invocation of His or Her Right to Remain Silent and Right to Counsel. This signature of mine on this document is in fact a forgery. Detective Joseph Kessling, who authored the police report that resulted in my current incarceration, in fact orchestrated this forgery. On July 18, 2017, the day of my arrest, Joseph Kessling witnessed me sign a waiver of my right to remain silent, thus performed a consented, recorded statement. What's a little thing like a conspiracy to forge an official document filed as a matter of court and public record involving an incarcerated person, an actual felony crime in and of itself, when you're colluding with many other state actors attempting to conceal the first ever state-sanctioned act of terrorism upon a U.S. citizen's business, the firebombing of my office, authorized by State Attorney Michael Satz himself. A first-degree felony punishable by life in prison, executed to cover up the death of a 19-year-old male who in fact died in October of 2009 due to the sinister interests of members within the Broward County State Attorney's Office and Broward Sheriff's Office attempting to secure the conviction of pain clinic Dr. Marilee Glauser, known to be experiencing the onset of Alzheimer's. Interests that outweighed the safety of the general public, costing this young man his life. Every bit as horrifying as the parents of this 19-year-old to this day have not a clue the truth of how and why their teenage child died. The list of actual felony crimes and constitutional rights violations committed by corrupt government officials surrounding these unprecedented circumstances goes on and on, allowing a defenseless 4-year-old girl to be repeatedly abused and molested, forcing witnesses to perform perjured testimony, fabricating transcripts, fabricating official documents, destroying the audio tape contained in digital recorder number 100118958 that in fact exonerates me in regards to case number 095531CF10A and proves police misconduct. I filed a motion to reduce bond in regards to instant case. During a hearing on August 16, 2017, in front of Honorable Judge Samuel Sloan, both prosecuting attorneys admitted that they reviewed this motion. In this motion, I presented an overwhelming amount of undisputed, verifiable facts filed as a matter of court and public record proving previously mentioned state-sanctioned firebombing of my office executed to cover up the death of the 19-year-old male. Also in said motion, I requested the presence of Assistant State Attorney Denise Nooner and Detective William Schwartz at the August 16, 2017 hearing because they know the name of the 19-year-old who was murdered. I do not. I also requested the presence of Detective Joseph Kessling and several other witnesses who would be able to give material testimony regarding previously mentioned forged document. The absence of these people being here today reveals the callous disregard the state has for the truth-seeking process involving matters of great public importance. I am not standing here today because I have committed any crimes against the state of Florida. I am standing here today due to my relentless duty-bound efforts over the past 8.5 years to expose the enormous number of crimes committed against me in the American way of life. Not only am I performing my duty as an American to report these heinous atrocities that places the safety of every human being within the boundaries of Broward County in great peril, according to Florida Statute 843.13, compounding felony, if I do not do exactly what I have been doing to expose these sadistic circumstances that remain intentionally unprosecuted, I would be committing a felony. I didn't know the situation as far as with the filings. I said after 37 days, the state has not filed the bogus misdemeanor charges. However, the state is now charging me with wholly bogus second-degree felony extortion charges. In light of the undisputed facts that I have brought forth, which are matters of great public importance and in the interest of justice, I request this court release me on my own recognizance, allowing my immediate release. Nobody of all the crimes that I'm stating, nobody is saying anything's false because of the evidence that I put forth. You can't dispute it. But I have the state who is saying, oh, well, he needs to be evaluated. I mean, I'm sorry, Your Honor, but when I put forth these facts that are undisputed, when you have a foreigner named Isabella Secu in the police report of the firebombing of my office, bragging and laughing about firebombing my office to the investigating officer to a point where there's nothing there, and stating that she was there at the time of the firebombing, she knew who did it, and that she actively participated in the firebombing of my office. But if the detective dare request her to show up to give testimony regarding her active participation to this first-degree felony, she's going to flee to her home country of Romania. I mean, the state has reviewed these undisputed facts, but yet they want to prosecute me for me performing my duty to expose these heinous crimes upon society as a whole. So, once again, nobody is disputing any of these facts that I'm putting forth. Not one of the judges, not one of the nobody. But see, when the entire system is corrupt, how do you penetrate it? How exactly do you penetrate it, Judge? Because I've been trying for 8.5 years.
Okay. Based on the affidavit which has been filed before the court today and the charges levied, the court is going to find probable cause as to all 17 charges. As before, the court is going to set a bond, and you guys help me out a little bit. Do I need to set as to
Apparently,
each separate count?
yes, so there were previous bonds set. Some of those counts have been removed
Correct.
because we have filed felonies. So if the court would be, I guess we'll have to file bond, and our clerks can help me on this, a bond for each of the new counts enumerated in the information. Is that right, Mr. Clerk?
The 4 felons are all that's on the document.
All that's on the docket is the 4 felonies. Okay, then
Okay,
then
then
we'll
those
just,
for the 4
then that's
felonies.
easy enough. We'll ask the court to set a bond of,
Okay.
as I said earlier, $25,000 per felony, with all the same conditions that you instituted before that he chose to break and violate.
Okay. For purposes of the hearing today, the court's going to set a bond on each one of the felonies of $25,000.
That was our request.
I'm going to set a bond of $25,000 for counts 1, 2, 3, and 4, all for extortion. I'm going to grant the state's motion to have Mr. Watson evaluated for competency. At this time, I've appointed shadow counsel to assist Mr. Watson, and I strongly suggest, based on what you just stated, sir, that you reach out to shadow counsel and see if you can get them to help you to prosecute your position in this case. All of the prior limitations and conditions that I set before in the prior hearing, the court is going to reinstitute and advise you, sir, that you are limited to contact to your family members and to your attorney. Other than that, you are not to have direct contact, sir, you're not to have direct contact with anybody else, certainly not to any of the people mentioned in the information, directly or indirectly, sir, directly or indirectly, or through any third parties except through a court hearing based on a proper motion filed procedurally correctly to allow you to have access to the court.
Okay, so if I contact somebody as a pro se litigant who I want to be a witness, you're not allowing me that due process right, is that correct?
That's wrong. I've appointed a shadow counsel for you. You can act through your shadow counsel to reach out to those people directly through your shadow counsel. Sir?
Time is of the essence, sir. I'm not gonna be waiving my right to speedy trial, so I mean, it's been like 37 days now, so I mean, I would really hope that this shadow counsel contacts me as soon as possible, please. And I would like to state for the record that the state is not denying any of my allegations, not a one of them.
Understood. I understand your statement, sir. Is there anything else we need to address?
Your Honor, just so the record's clear, in case Mr. Watson really did need to know, since the state's convinced that he's not competent, therefore anything he's alleging is not to be believed. Therefore, we don't agree with any of the things he's put in any of his motions, pleadings, or statements. Having said that, we still believe he's not competent, and therefore, they're the rantings of a delusional person.
The
That
court's
should explain-
granted your motion,
Thank you.
so hopefully we'll find out in the future.
Right. I don't know how that works, so the clerk here in Broward, in Dade I would know, but Broward I don't, so what do we do?
Well, I'm signing. That's for pretrial, okay. And I'm finding probable cause, as stated, ordering the competency evaluation, ordering the conflict counsel or shadow counsel on behalf of Mr. Watson.
Your Honor, I would ask the clerk, Mr. Clerk, is there something that has to be done now to have him evaluated?
Yeah, the sooner the
Judge
better,
just,
please.
just signed an order, I thought.
Your Honor,
I don't know whether I just signed
we
an
have an
order for
order
competency.
from me?
Yes, sir.
I don't have one.
and
Okay,
my name is Eric Linder. I'm an assistant state attorney in Broward, and I'm not providing any information or making any argument with regard to these cases that are in executive assignment. I'm just offering, as a friend of the court, with regards to procedures.
Yes, sir.
Your Honor, what has been done in this division in the past is that court administration has been contacted to send a representative from court administration, and what they can do is prepare the paperwork for the evaluation, for Your Honor to pick a doctor to do the evaluation.
No problem.
okay, so.
And
how
do we
we-
get an
just need to ask
arraignment
the clerk.
date signed at this point?
I believe there's an arraignment date already scheduled for the 28th, but I'm not sure if Judge Tunis intends to do that or set another date. I haven't been able, we have not, there's been no contact from Judge Tunis yet.
You can request the clerk to contact court administration to send someone up here because you want to order a competency evaluation.
Okay.
Clerk?
All right, sir, you'll be notified of the arraignment date, and I'll ask court administration to have somebody come up with the appropriate order for me on the competency evaluation.
Since he does.
Normally, what is competency or not done in magistrate court, they're normally done with the division judge. So we have to find out how that's gonna work.
Okay.
Your Honor?
Sir.
If it will make it easier for the clerks and everybody, we've requested it, you've made the ruling. I will prepare an order and bring it at the arraignment for whoever
Okay.
the judge is. If that would be, Madam Clerk, will that assist you? If we, yeah, that'll work? All right, we'll do that. We'll bring an order for the arraignment, and then the circuit judge that will be handling it can either agree and sign or not, and we can go forward from there.
One last question from the clerk. Since I've appointed a conflict attorney as a shadow attorney, how is that handled? Okay,
Okay, that works.
all right.
Okay, thank you, Your Honor.
Hopefully your attorney will contact you as soon as they're selected by the clerk off the wheel, sir. and then you can make your
Broward County
decision.
Clerk's office, the Broward County Clerk's office is the one who's picking this?
Well, there's a wheel, there's a procedure that's done here on a wheel. The judges don't pick it, it's all done through the clerk's office. All right, sir? All right, good luck, Mr. Watson.
Thank you.
Okay, we're gonna take a short recess, folks.
Ready? Okay, good afternoon, everyone. I'm Judge DeLuca. Welcome to Broward County First Appearance Court. At the main jail, can you hear us okay?
Yes, we can, Judge.
Okay. We're, clerk ready to proceed? Okay, do we have a pretrial over there?
Yes, sir.
You all set?
I am ready.
You're always ready. State ready to proceed?
Yes, Judge.
Please state your appearance.
Eric Linder on behalf of the state, Judge.
Attorney from the Public Defender's Office in the courtroom, please state your appearance.
Brian Reedy from the Public Defender's Office.
And do we have an attorney? Yes, we do, at the main jail. Please state your appearance as well.
Mayor, on behalf of the Public Defender's Office.
Okay. Mr. Rotterman, what do you have?
I have Ricky Shapiro. I don't think he was here earlier. I apologize, I was here for a few moments this morning earlier, but hadn't been hired by the family. I've had an
Hold
opportunity.
on one second. Mr. Ricky Shapiro?
Mr. Ricky Shapiro is housed here at Main, Judge. They're going to get him. They're getting him now.
They're getting him now? Mr. Rotterman, do you have a few moments so that
Yeah,
your
Judge,
client
I
can...
I can waive his appearance temporarily and just give your honor. the
Well, why don't
basis.
you just wait till he gets here so that he has the benefits
Okay,
of us?
great. Yeah, you're right, Judge.
Okay, all right. Michael McLeod?
Mr. McCloud, come on up, please. He's approaching. He's here at Main.
Judge, while we waiting, can you verify count 4, the warrant number is 17CR184 on the finding?
17CF184, that's what I have on the cover
Okay, it
sheet.
should be CR.
CR?
Yes.
Thank you, ma'am. Mr. McLeod, you're charged with the first count of false information to a law enforcement officer, a violation of probation or community control in case number 1622801, an out-of-state hold on the felony for the same charge, and an out-of-state hold for, under case number 17CR184. I do in fact find probable cause as to each respective case. Bond is set to count 1 as $100, counts 2, 3, and 4 are no bond. Do we have a court appearance date, the next court appearance date for Mr. McLeod?
No, Your Honor, it's because all the hearings, the VOPs and stuff are either out of county or out of state.
Okay, thank you, Mr. Linder. Mr. McLeod, have a good day, sir. Mr. Clerk, are these the afternoon cases? What are these? Okay. Mr. Romero, let us know when Mr. Shapiro is up.
I will.
Okay. Jotham Slater?
North Broward.
North Broward, Your Honor. He's approaching. Slater.
Bill? Do we have another chair for the judge?
Sir.
Mr. Slater, you have an out-of-state hold on a felony under case number CR 3381105. I do find probable cause. Bond is set at no bond. Have a good day, sir. Close control gives us a different jail.
Your
It's
mouse
North
blocks
Broward.
it.
This is the main jail. There's a delay, so when you touch it, wait, 'cause you want to keep turning it back and forth. Okay, Tiffany Jane Cox?
North Broward.
Mr. Cox. Good afternoon, sir.
Good afternoon, Ms. Cox. We're here for a limited purpose of determining probable cause. You have two capiases for misdemeanors.
Sir, yes, sir.
Under case number 170-29256 TC20. Bond is set at $1,000 on each case. It looks like leaving the scene of an accident and driving while license suspended.
Yes, sir.
Okay, the warrants were issued on, let's see. Looks like, was it August 17th?
Yes, sir, it should be.
Okay.
I just got the court dates mixed up. I thought it was the 18th and not the 13th.
Do we have any other any other failures to appear?
Your Honor, I'll check.
I don't have any other
looks-
failures.
It looks on the
Hang on,
capias
Tiffany, hang on.
that it was issued July 27th.
July 27th?
That's what that's what I have on my copy of the capias.
You're probably correct, Mr. Linden.
Let me check.
See, they're not giving us the reason in the paperwork, how they came in contact with Ms. Cox. So that's an unknown. Okay. A north case. North is 20, central is 10, west is 30, and south is 40. Do we have any information what the nature of the contact was with Ms. Cox why the police came in contact with her yesterday?
My tire fell off the car. The car was in. The
Tiffany,
tire came
don't
off.
say anything, Tiffany. Anything you say is being recorded.
That's Mr. Reedy, an attorney with the Public Defender's Office.
It's a bit dated, Your Honor, but I am showing in 2005, a capias was issued on a traffic matter by Judge Schiff. She was arrested in 06 on the capias.
That's going back a ways, Judge.
Excuse me, I was released
don't
in
say anything
2005
yet.
from prison.
I said it's dated.
Remember about me telling you not to say anything?
But you didn't speak to me properly, sir.
Well, Judge, Miss Cox has lived here all of her life. I've spoken with her mother. Her mother does not have the money to bond her out, but she does have a place to stay.
Jesus.
I'd ask the court to consider pretrial release. These are nonviolent misdemeanor charges.
Pre-trial, have you had the opportunity to interview Ms. Cox?
No, Your Honor, we typically don't look at failures to appear, as is this case.
I don't either, but it seems like $2,000 for bond seems a little bit, State, do we have any priors?
Yes, Judge.
What kind of priors?
$2,000 aggravated fleeing and eluding, leaving the scene of an accident in a DWLS. She ended up being sentenced to 2-year state prison. 99, leaving the scene of an accident. 1999, aggravated fleeing and eluding, grand theft auto with a VOP 3 years. I think part of the bond might have to do also with the nature, not just the failure to appear, but the nature of the offense in and of itself, leaving the scene of an accident.
Judge, the state has to go back pretty far to find serious charges against Ms. Cox.
Yeah, what they see, I don't know.
17, 18 years ago.
But I don't know if these are, I don't know if these will come to fruition, but it certainly seems to be a pattern that, but, Ms. Cox,
Sir, yes, sir.
let me hear from Mr. Reedy as to the bond amount.
Well, Judge, I'd like you to consider pretrial release for her. After speaking with her mother, I don't know that there's really any money in the family to bond her out. I believe she can stay there. As I say, she's lived here all of her
Assuming that I
life.
don't feel comfortable with pretrial release, what would you recommend as a bond amount?
Maybe cut it in half, 500 each count.
Ms. Cox, if I reduce the bond, will you get up and see whatever judge has your case up in Deerfield Beach and get this taken care of?
Sir, yes, sir, but I don't have the money to bond out. There's nothing in my family. I've gave my mom my last bit to fix the house up. My mom's 77. I was protecting a client last year and lost my job. I've been trying to get one since. I have a job waiting for me. He was waiting for me to get this court date to get on with it. I was the past 3 days before this, I was literally asking someone to take me to the courthouse to take care of this court date. I don't want to lose my job. It took me a very long time to get this job.
I don't want you to lose your job either. I want you to show up in court. I don't care what happens when you show up.
It was just a mistake. I mistook the 13th for the 18th.
Okay, Mr. Reedy prefers that you don't say anything, and he's probably correct. Pretrial, can we interview Ms. Cox for pretrial?
We can.
Okay. Okay, I'm gonna reduce the.
Reset for tomorrow though, because I have no one to interview her right now.
Okay, this is what we're gonna do, is I'm going to reset for tomorrow to see where we're at with pretrial. In the interim, I'm gonna reduce the bond to $500 per count. If you're able to post the bond, then we don't need to see you tomorrow. If you're still in, then we'll see if you qualify for pretrial.
Well, Your
Throwing
Honor,
this upside down,
based on
or do you
her
want to put them all
charge, you know
together?
She doesn't qualify, so you just want me to verify her.
Yes, please.
Yeah, because we know,
I understand.
no problem.
Thank you. Thank you, ma'am. We'll see you, hopefully we don't see you tomorrow. Hopefully you're able to get out. Tina Dotson?
There is one case the jail wanted you to call out of order if you could. That'd be Andre Hudson on page 8.
Let me take Ms. Dotson while she's here right now. You have a capias on a misdemeanor,
Yes, sir.
trespass on school grounds. I do find probable cause, bond is set at $250. Have a
I don't
good
know
day,
if
Ms.
Ms.
Dotson.
Dotson would consider perhaps resolving this matter this afternoon.
I would, because my daughter is disabled. How can I get a trespassing on campus when she's
I wouldn't talk
disabled?
about the facts of the case, Ms. Dotson. Let's see if we can come up with a resolution that you might find satisfactory.
I declined, but based on the nature of the charge, there could be too much of a variation. I declined to offer a plea based on the limited information that I have this afternoon. Have a good day, ma'am. The bond is $250. Mr. Reedy, what case do you want?
Page 8, Andre Watson.
Hudson. It's Hudson, Judge.
Andre Hudson.
Yes, sir.
Mr. Hudson, you're charged with possession of a weapon or ammunition by a convicted felon.
I understand that.
I do find probable cause. State, do you have a recommendation as to the bond?
Yes, Your Honor, reading the probable cause affidavit, frankly, I have a concern for Mr. Hudson's well-being, also right now for anyone he may come into contact with. Additionally, his record, while dated, is concerning. 1998, battery on a detention staff member, 5-year state prison as a habitual offender, PRR offender. 97, strong arm robbery, 15-year state prison as a habitual offender, PRR offender. He had an attempted strong arm robbery in 89 where he was sentenced to 5 years. Another strong arm robbery in 87, burglary of a dwelling in 88. Your Honor, I'm going to be requesting bond in the amount of $15,000. And should Mr. Hudson post his bond, pretrial release with a GPS monitor?
Mr. Reedy?
Your Honor, Mr. Hudson has been living in Florida for an extensive period of time. He does have family here, including his aunt. He has been staying with his uncle for the last couple of months prior to his arrest. He attended Dillard High School, and right now, unfortunately for him, he's between jobs. He doesn't have a lot of money available to him, so it asks the court to consider his current financial situation when posting or setting a reasonable bond in Mr. Hudson's case.
What, let me ask this. The booking sheet I notice has his address as at-large, 0 months of residence, and we know that's not always correct. But getting to the probable cause affidavit, the probable cause affidavit indicates that there's psychotic behavior, that Mr. Hudson was not taking his medications. He had threatened to kill himself, and that he threatened to kill another person, and that he is a Florida career offender. Is there anything that we want to address as far as getting Mr. Hudson some help? Or evaluations?
Now that Mr. Hudson has been appointed as a client of the Public Defender's Office, Your Honor, that's something we'll look into internally.
Thank you, sir. At this point, based upon the argument, the respective counsel and the applicable law, the bond is set at $15,000. Special condition, pretrial release with GPS monitor, pending further evaluations and review. Have a good day, Mr. Hudson.
Can I say something?
Sir,
I would advise you not to, Andre. We're gonna have somebody come up and see you very soon, all right?
Barbara Rudolph. How are we coming on, Mr. Belisario?
He's here?
That's Shapiro.
I announced like 2 clients ago he was ready.
Thank you, sir. My apologies. We'll get Mr. Belisario next. Barbara Rudolph. Ms. Rudolph, you have a new charge for DUI, refusal, and driver's license not carried and on the wrong side of the road. Those are both traffic infractions. Upon review of the probable cause affidavit, I do find probable cause as to each respective count. Pretrial, was Ms. Rudolph interviewed for pretrial?
No, Your Honor, based on the fact that this is a felony DUI, fourth or subsequent, that alone, we would need to disqualify her from us making a recommendation.
So I just wanted to make sure that verified.
Yes, ma'am. State of a recommendation for a bond?
Your Honor, because this is a 4th DUI, the state would be requesting a $7,500 bond with a release condition that Ms. Rudolph not imbibe in any alcohol or intoxicating substances. That's not a bad idea.
Defense care to be heard?
Yes, Your Honor. I'm sure Ms. Rudolph would have no problem complying with whatever special conditions of either pretrial release or bond that this court was to impose. You can place her on pretrial release if you so decide to do so. She's been living here for 30 years. She has extensive family here, including her mother and father and her brother. She's been living by herself in the same location since March of this year. She's a paralegal. She's been working at the same place for 1 year. She gave me the name and number of her friend Tasha, who I've spoken to. Tasha says that she's going to do everything that she can to come up with a bond for Ms. Rudolph. She's not exactly sure how much money she's going to be able to come up with, so I would ask the court to set a bond that they can afford, which may be lower than $7,500. I ask for a $2,500 bond. And if the court wanted to make it a condition of her release that she wears a GPS monitor that tracks any alcohol she might consume, I'm sure Ms. Rudolph, in exchange of getting out of custody, would be glad to abide by that condition.
Your Honor, I would suggest not a GPS monitor, but a transdermal alcohol detector based on the fact that this is her fourth or subsequent DUI.
That's exactly the device I was thinking of. Thank you, Madam Pretrial.
Your Honor, I would just note, it appears, and there's reason to believe that there may be some financial means, noting that the defendant's vehicle is a 2015 Nissan, relatively new, so.
It's like $250 a month. I know, my wife just bought a car, so. I'd also point out, Judge, that she was capable of understanding all of the warnings that were given to her, so it wasn't as though she wasn't capable, according to the officer, of understanding what was being told to her.
And she almost struck his vehicle.
Upon a review of the probable cause affidavit, the argument of respective counsel and the applicable law, I'm going to impose a bond of $2,500 for each counts 1 and 2 for a total bond of $5,000. Special condition, no alcohol or intoxicants, and the transdermal alcohol detector.
Yes, Your Honor, correct. TAD, T-A-D.
TAD?
Yes, Your Honor.
Have a good day, Ms. Rudolph.
Barbara, do you understand?
Yes,
All right,
thank you.
I'm gonna call Tasha back, okay?
Please, thank you.
Russell
You're welcome.
Belisario?
Well, Your Honor, I think it's Ricky Shapiro.
Ricky Shapiro. Ricky Shapiro. Ricky Shapiro, where's that paperwork? Oh, those are traffic infractions, so there's no bond on them.
It was reset from this morning. Yeah. What's that?
Do we
Yeah,
have
give or
the
take.
Ricky Shapiro report?
If you wanna go, well, you gotta go straight.
Here it is, I got it. Mr. Shapiro?
Yes, sir.
Mr. Rotterman was here this morning for you. He's back this afternoon. And you have a couple of people with you, Mr. Rotterman?
Yes, Your Honor. I
And
have
who is
his
that, sir?
wife, Michelle Shapiro, of many years. They have 3 children together, stepchildren that he's adopted, and his aunt, Sarah Miller, both of which I've talked to at length at my office.
Your wife and your aunt are here at this time. And you care to be
I
heard?
see them, Your Honor.
There's a warrant for accessory after the fact of first-degree murder. Mr. Rotterman, do you care to be heard on probable cause?
Yes, Judge, if I may.
Yes, sir.
I haven't had a lot of time, as you know. I must admit, though, the new facilities here in these courtrooms are a little bit left to be desired in terms of this this roster here, but be it as it may, I'll get down here and do it the best I can. Judge, yes, I reviewed it, and I see that out of the 15-page probable cause affidavit, there's like 1 or 2 sentences that relate to my client. Apparently, the 2 co-defendants in this case were arrested quite some time ago and charged with first-degree murder in terms of a shooting that took place in a bar parking lot. My client apparently is alleged to have somehow had a bag of one of the co-defendants that apparently had the weapon in it. It was seen put on a pool table and then retrieved from the pool table and then given to one of the co-defendants. He has a lot of good things to argue, Judge, and I think in terms of a reasonable bond. First of all, he's been in Florida his entire life. He's 37 years old. His parents work for American Express. He has 3 stepchildren, Miranda, Hallie, and Terry. His wife, Michelle Shapiro, works for a online shipping company here in Broward County and has for several years. He has a learning disability. He's very immature, apparently a low IQ and some problems. So his family tells me what's the big issue here is that he is the kind of person that's easily influenced and very naive. And he got involved with these younger people that I think are 20, 21 years old, one of which may even be a gang member. I don't know, the one that apparently was involved in the actual shooting. In light of the fact that these other 2 co-defendants were arrested like 10 months ago, and my client having resided in Broward County all of his life and 5 years at the particular residence that he's at now, I would ask the court to consider the fact that if they wanted him, they could come get him. Apparently, one of the co-defendants did, in fact, negotiate some kind of a plea to a 2nd degree or less with the state and cooperated and indicated that my client may have known that one of the co-defendants had a gun. I think this whole shooting took place, and correct me if I'm wrong, this was like kind of a spontaneous thing. This gentleman was kicked out of a bar for being drunk, the alleged victim, and apparently it was confrontational with all other patrons of the bar. And this one gentleman was the one that retrieved the gun. They got into a fight in the parking lot. This alleged victim left in his car but came back. And there was another confrontation. He was shot. My client was nowhere near that particular incident, nor did he participate in any way. Like I say, looking at the evidence in the light most favorable to the state, what they have here is they have a gentleman, my client, that may have known that this guy had a weapon or a firearm in a bag that he gave to one of the co-defendants, but that's his total involvement. So I'd ask the court to set a reasonable bond, whatever conditions Your Honor would prefer to have, even a monitor, but I know that he's limited in his finances. I know his aunt's trying to help out. It's his mother's sister, and she is very cooperative, willing to help, but she's limited in funds as well. So I know the state was going to recommend a pretty high bond, but I'd ask the court to consider multiple factors. And in summation, Judge, is that his roots in the community, the same address for 5 years, no record whatsoever, I understand, in 10 months since the original 2 defendants were arrested, and not hit him. There's no flight risk or no danger to any of the witnesses. I've agreed with the state, or will agree with the state, that he'll have no contact whatsoever with any of these people, or even go near that bar. And that's pretty much my argument, Your Honor.
Thank you, Mr. Rotterman. We'll come back to you in a moment. Mr. Linder?
Thank you, thank you, Your Honor. Your Honor, the state is going to be requesting a bond in the amount of $100,000. Should Mr. Shapiro post his bond pretrial release with a GPS monitor level 1, and an order from the court of no contact with either of the co-defendants, Carlton and Carey, and also no contact with any of the listed witnesses. Your Honor, first I would note, and noting on the booking sheet, it actually has it listed as a second-degree felony, but because it's actually a first-degree felony, accessory after the fact of a capital offense. So that is, I think, something the court should take into consideration and the potential consequences that Mr. Shapiro faces. Additionally, just based on the nature of the charges, Your Honor, I do believe Mr. Shapiro does, to some degree, pose a threat to the integrity of the judicial process, which is a factor for the court to consider under the Rules of Criminal Procedure 3.131. Your Honor, the facts before the court in the affidavit, in the sworn affidavit, is that two witnesses provided statements that Mr. Shapiro knowingly and intentionally removed a bag containing a handgun that was used in a murder, first-degree murder, for the purposes of getting rid of the evidence, Your Honor, the murder weapon. The concern going forward is if he's willing to do that, that he may be willing to take other measures and to protect the co-defendants in this matter, Your Honor. And because we're dealing with a first-degree murder as the underlying offense, the concern has to be even greater.
Judge, I think that's a stretch. Obviously, the only evidence there is this one sentence I'm reading at a 15-page, single-spaced probable cause affidavit or complaint where it says that at this point there was a video where the aforementioned defendant, Ricky Shapiro, herein referred to as the defendant, first becomes involved in the incident. Shapiro is observed taking a large bag off of a pool table and subsequently exiting the establishment with his bag. Apparently the bag was then placed on the table by a witness, GB, after he removes it from the room entered into by Carlton and witness, JH. I mean, you can't be any more minimally involved in something than that. Who's to know that he knew what was in the bag? I mean, that's, so I think it's a stretch. I would ask the court to consider a reasonable bond. He has family, roots, no prior record. Inevitably, eventually, if in fact I'm correct, he probably will cooperate to the extent that he's only involved in the periphery at best. And I think he's entitled to a reasonable bond, Judge. $100,000 is no bond at all. They can't make that.
And Your Honor, just for the record, I'm referring to the allegations contained in the last few paragraphs going from pages 11 of 13 to 12 of 13.
Yes, sir. I read them earlier today as well. The booking sheet indicates a Royal Palm Beach Boulevard address, but it says 0 months of residence. That's incorrect, Mr.
No, that's
Rotterman?
incorrect. Can you give the court your address now for 5 years? Can you tell us what it is, please? Coral Springs, Your Honor.
And, Mr. Rotterman, I know you went through a lot of information, but is you indicated, is Mr. Shapiro employed?
Yes, he's got 2 jobs. You want to tell us what they are? I'm sorry, Judge, it's Spares Bowling Alley and Davy.
How long has he been working there?
Since April. Prior to that, where was he working?
Anything else by the state?
Nothing further from the state, Judge.
I'm telling you what I'm thinking. I'm thinking of a $50,000 bond, but if Mr. Shapiro is able to post a bond, then GPS monitor but house arrest, except for the purpose of employment. Or I could just do a straight $100,000 bond with the GPS without the requirement of house arrest.
Judge.
Mr. Rotterman, you want to speak to the family on that?
Yeah, I mean, obviously, we'd prefer to have the lesser amount of money in terms of saving some money so he can use it for his defense, but I disagree with the court, and it's rare, but I think that bond is excessive, but I guess out of the 2 choices, that would be the better choice.
Then upon the argument of respective counsel, the facts of the case, the applicable law, the court sets bonding amount to $50,000, special condition GPS monitor, house arrest, with the exception of attending any religious organizations or employment.
Judge, does that also include medical, shopping, visiting with counsel? And
Visiting with counsel, not shopping, and certainly medical.
okay, great.
Okay. Anything else,
Your Honor, I just had a request about no contact with the
no
co-defendants.
contact with any of the victims or witnesses in the matter, indirectly or directly, without further order of the court of competent jurisdiction.
And, Your Honor, and obviously this, we're asking for no willful contact with co-defendants Carlton and, I'm sorry, with, there's so many names in here, Gerald Carey and Dalton Carlton. I understand
Carey. I'm sorry.
Gerald Carey and Dalton Carlton, while they remain in custody, you know, there may be, you know, if they're in this, happen to be in the same place at the same time, or classifications can take care of that also. But my concern, obviously, based on these allegations, I have concerns about them communicating with one another.
I don't believe he wants to have contact with him anyway, so that's pretty fair.
Well, I'll order no contact, but certainly we have to be concerned that if the jail messes up, but inadvertently, he's not,
and that's why
he's not held responsible.
No, and that's why I asked for willful. Obviously, in the situation you're describing, which would be my concern also, that wouldn't be willful.
Well, we've learned over the years when we get into willful, that's
Kind of
becomes unenforceable.
Okay, with the court,
I'm just gonna say no contact, and if it becomes a situation where it's involuntary, I think we can adequately address that.
I appreciate that, Judge.
Anything else, Mr.
No,
Rotterman?
Your Honor. Thank you, Judge.
Thank you.
Your Honor, we have another private attorney present.
Ms. Horowitz, who's your client?
Good afternoon, Your Honor. Nice to see you.
Nice to see you as well. And-
Thank you. Melanie Horowitz, behalf of Raymond Delmonico. I understand you called my office this morning.
Yes, we did. Raymond Delmonico.
And just for the record, we had called we thought we had to call Judge Shearer's office this morning, which we did first thing this morning, and to get a court date. And so we didn't know to be here earlier this morning, and
That's perfectly fine. I'm looking for the booking information for Mr. Delmonico. Mr. Clerk, do you have that over there? I don't seem to have it here.
No, this afternoon's not on the dock. This was a violation of probation from this morning?
This was
Yes.
from this morning.
Right, and it was a no bond hold, right? I don't remember him being reset. I could be wrong.
No, we reset it because we tried to call Ms. Horowitz's office.
you did reach my assistant.
Can we get the paperwork since and is your client, is Mr. Delmonico here at the jail?
It's in custody, Your Honor.
I know he's in custody, but is he here as far as in the jail for today's proceedings? Mr. Clerk, hold on 1 second. Is Mr. Delmonico there at the jail?
No, he wasn't on the docket. I believe
Okay,
his
so
matter was addressed.
it got reset for tomorrow? Is it reset for tomorrow morning or afternoon? The morning or afternoon? Morning. Ms. Horowitz is set for tomorrow morning, so I apologize to you. See you tomorrow morning.
What time is tomorrow morning? What time tomorrow morning?
9 o'clock.
9 o'clock.
8:30, I'm sorry.
Okay, and just so I know, so I have a range, because I have another case in this building, how long are you here for?
I can't tell you. I mean,
Okay,
usually it goes at least till 9:30, 10 o'clock.
okay. So I will be here tomorrow.
Okay. Thanks, good to see you.
Nice to see you too. I take it there's no way to bring him over to have it heard today.
No, it's not at this point. Okay, thank you.
Your Honor, may I ask you one question?
Yes, sir, of course.
On this Shapiro, is he entitled to work? He has a job. Is he allowed to work?
Judge did say he could.
Yes.
He is? Okay,
Yes, sir.
great. Thank you, Judge.
Lakeisha Calloway?
North Broward.
Good afternoon, Ms. Calloway. You have a new substantive offense for grand theft. You have a capias for misdemeanor traffic and one for a misdemeanor on 16003362 MM 40A, which appears to be a petty theft.
Judge, her bond was posted.
Bond has been posted?
Yes.
Your bond is 1,000, counts 1, 250, count 2, and 500, count 3. And I've been advised by the jail that your bond has been posted, ma'am. I wish you good luck. Have a good day. Okay, Dante Harrington.
Judge, I've been advised he bonded.
Mr. Harrington had a bond of $250. I've been advised he's bonded. Have a good day. Thomas Grant.
Mr. Grant, come on up. Judge, this is a county ordinance case. Public Defender's Office doesn't represent County 1.
I just have to.
Can anyone tell me what the underlying violation is that's pending?
It's open container.
Okay, thank you, sir. Do you have any other cases pending, Mr. Grant, besides the
No,
open
sir.
container case? Are you
No,
on
sir.
are you on probation under any name, anywhere, for any purpose?
No.
Okay.
Well, I start work Monday, so I turn myself in so I can start work.
Okay, let me ask you this, is your current address still apartment number 2 on 9th Avenue?
Deerfield?
I have Wilton Manors here, sir.
No, it's Deerfield.
Okay. 3071 Northwest 9th Avenue?
No, I just recently moved in with my brother.
Okay. And when you get out, is that where you're going to return?
Yes, sir.
Okay. Now, this is let me explain the circumstances here. This is a municipal ordinance violation, and because of that, the state attorney that's here in the courtroom is not the prosecutor on your case.
Your Honor, is this Mr. Grant?
Grant, Thomas
Yeah,
Grant?
this is a county, it looks like this is a county ordinance, and I would, actually, the state would handle these.
Okay.
I,
But you don't have the services of an attorney from the public defender's office. So let's see, state, what's your offer?
Your Honor, I don't offer him a withhold court cost consideration, and,
Any
judicial
prior?
notice of time served. I'll check.
Mr. Grant, you don't have to tell me, but it would move things along. You have any other arrests anywhere under any name?
Sir?
Do you have any other arrests anywhere under any name?
Under any name? No, sir.
Okay.
It looks like there was a battery arrest in 2015, but it was dropped. That's all I'm showing.
Yeah.
So you don't have any criminal convictions on your record?
Not that I know of, not in the state of Texas, but in the state of Texas I do.
And Your Honor, I have to know, my system that shows out of state, it's down right now, so I don't have an ability to check that.
Well, these are the options we have. I do find probable cause. The scheduled bond on the warrant is $250. Here's the thing, we can discuss lowering the bond to get you out so you can go take the job that you're supposed to start. Or if you want to get it over with today, I'm gonna adjudicate your time served. You will have a conviction from this, and I'll give you 6 months to pay whatever the fines and court costs are for that. But I don't want you to take the plea just because you want to get out today, because if you feel you are innocent, I want to let you have your day in court, and we'll address the bond status to get you out. So, but if you want to get it over with today, it's probably an opportunity that you might want to consider.
Let's get it over with, I guess. Can I get it over with?
Yes, sir. You plead no contest?
Yes, sir.
Okay. You don't have to, if you want to get it over with, the words have to come out of your mouth.
Yes, I want to get it over. I want to start my job Monday.
No contest?
No contact.
Okay. Mr. Linder, you also were mentioning a judicial notice of time.
Well,
served
that's,
to-
if it's adjudication
to
time served,
avoid-
it's not
But
necessary.
I could withhold and do the,
My understanding, that would make it a legal sentence if you take judicial notice.
okay. What I'm gonna do is I'm gonna withhold adjudication, I'm gonna take judicial notice of the time served, impose the court costs, and give you 6 months in which to pay. Is that acceptable to you, Mr. Grant?
Yes, sir.
I wish you good luck. Good luck on the new job.
Thank you.
Thank you, sir. Lione Levine.
No problem.
Conti, okay, sorry about that. Okay. Liney Levine? Mr. Levine, you're charged with trespass after warning.
I'm sorry, wrong person, I'm sorry.
Okay,
Mr. Levine is in North Broward, Judge.
okay, we're at North Broward and we have a blank screen.
It's just been that kind of afternoon.
You, Mr. Levine? I don't have any sound over at the, coming in. Thank you, Deputy. Mr. Levine, can you hear me okay?
Yes, sir.
Okay, Mr. Levine, you're charged with trespass after warning at a Walgreens. I do find probable cause and bond is set at the amount of $100.
Why not, sir?
I'm sorry?
Why would you find proper cause on me when I have pending issues that I haven't got served? You know what I mean? I'm mental that way. You know what I'm saying? My address is 305 address. They say I asked for cigarettes. I smoked 305 cigarettes. I haven't had a question on nothing. You know?
Okay, so you're, do we have any opportunity to,
I don't like them. You know, I don't like the people in the community.
okay, there's a lot of people I don't like
I
either.
don't live for them, sir. You know what I mean?
Yes, sir.
Your Honor.
What resources do we have
That's the
available?
big
that-
issue.
You might want to transfer him to Judge Lerner Wren, her mental health division.
Does Mr. Levine have any prior cases with Judge Lerner Wren?
I didn't see any prior cases in that division.
Well, I'm gonna find probable cause. Bond is set at $100. We're gonna transfer this to Judge Lerner Wren's division.
First place, sir, I haven't done anything illegal. You know what I mean?
Sir, I'm not making a determination that you have.
All my things are being stolen that way.
I understand, but we're gonna
That's why
get evaluations in place.
We
The
forgot to
public
bring our
defender will
stamps
do a
with
good
us.
job representing you, and hopefully we come to the proper resolutions. Have a good day, Mr. Levine.
Thank you, sir.
Okay. Sergio Pina.
Mr. Pena is here, present Judge at Maine. He has a private counsel, Mr. Josh Rydell.
By any chance, Mr. Pina, do you have Mr. Rydell's phone number?
I do not have it on my person. It is in my cell phone, which I
Hold on.
have a court order that from earlier today that was not.
Hold on. Let me see if I can get it here. Give it to you.
Judge, Mr. Pena,
Good for you. Thank you, sir. 779.
1711.
Let's see if we can get him on the phone for you.
All right, thank you.
Yes, good afternoon. This is Judge DeLuca calling from the courtroom. We are on the record. Everything is being recorded. Is Mr. Rydell available, please?
Sure. Can you give me 1 second?
Take your time, ma'am.
Okay.
We have plenty of time.
Okay.
You'll fill out the transfer information, sir? Yes. Okay. Relinquishing judge.
Yeah. Excuse me, while you're on hold. He was remanded yesterday.
It's Josh Rydell.
He's only here.
Mr. Rydell, Judge DeLuca in the courtroom. Hold on 1 second, sir. We are on the record. Everything's being recorded. Yes, ma'am?
He was remanded yesterday into custody by his division judge.
By
So
his
for
division
May-
judge?
Yes.
Okay, Mr. Rydell, I'm doing first appearance in the afternoon session, obviously, with downtown across the street. And Mr. Sergio Pena is here. Apparently, he was remanded yesterday, and we're doing the first appearance, and I wanted to reach out to you to see if you're representing Mr. Pena and how you want to proceed.
I'm having a very difficult time hearing you. I am representing Mr. Pena. I for some reason can't hear you that well. What is he being remagistrated on the
Grand,
what he's-
yeah, there are 6 counts of grand theft. I can't, hold on 1 second. Let me turn off the background noise. Might be a little bit better now, and
Much better.
and unfortunately, because we need to have a record, I need to keep you on the speakerphone.
Understood, Judge, completely.
There are 6 counts of grand theft, let's see, 1, 2, looks like 5 counts of false ownership for pawning information, several counts of dealing in stolen property, and it looks like maybe the dealing and stolen property counts, which are 13, 14, 15, 16, and 17, looks like these are new substantive counts. Everything else has a capious number next to it, or an existing count.
Yeah, I just pulled it up. I see it all. I see it all as well.
Now, are you across the street?
Almost, yeah.
Do you want me to put this on recall and you want to come over, or you want to handle it telephonically?
Judge, I'm happy to handle it telephonically.
Okay. The bond schedule for counts 1 through 6, the grand thefts are 1,000 each. The capious under 16,000,309, maybe. MM20 is $15,000. Mr. Linder, is that correct? A $15,000 bond on a misdemeanor?
Your Honor, I checked on Odyssey. The reason I believe Judge Solomon set the $15,000 bond is that the hearing that Mr. Pena didn't show up to wasn't just his arraignment. There was also a motion to revoke bond filed by the state.
Okay, so it appears that was a, I actually had, the reason I question is I had a problem last week and it was purely my fault and probation did a great job. When I wrote the $sign, it appeared to somebody as the number 4. I was like, okay, that was my mistake and I'm glad they caught that. But let's get Mr. Rydell taken care of. So now we have a new substantive charge of false information for a pawn. 1, 2, 3, 4, 5 counts, and looks like 6 counts of dealing in stolen property.
There's actually,
These look like, these are
Okay.
new add charges because they do not have any capious or warrant numbers on them.
yes.
And there's also a status to be set, and I can't read the handwriting of which judge it's on.
Judge Merrigan.
This doesn't look like it's Merrigan.
Oh, is on the misdemeanor or the felony? Judge Solomon on the misdemeanor.
Thank you.
I do find probable cause to each count. The bonds for counts 8, 9, 10, 11, 12 is $1,000, and the bonds for 13.
Well, Judge, if I may just have just a brief comment in regarding the false ownership counts.
Yes, sir,
Or the
absolutely.
dealing in stolen counts. Judge, just so the court's aware, it doesn't make it good, bad, or indifferent, but Mr. Pena has a couple matters pending in front of Judge Merrigan. Some of these issues, these residual issues, came to light in front of Judge Merrigan that essentially all of Mr. Pena's issues, so it's going to be about 3 or 4 different felony counts, they didn't inherently violate each other. These were all counts that came to light through the arrest process and the bond process and things of that nature. So he is legally bondable on all that. You're not. There's no position to revoke the bond. So all I'm asking, Judge, is if you could just set a $1,000 threshold on everything. I've already been working with a surety agent to try to get him bonded, and that's what I'm going to be trying to do for Mr. Pena, if the court be amenable. So the only ones I'm addressing would be what you're showing as the dealing in stolen, which is currently listed as 35. Because I'll be candid with you, Judge, I believe it's duplicitous. There's case law out there that states the state attorney cannot take to a jury unless it's for the true issue of fleecing. You know, when we talk about fleecing goods, the multiple charges. So, for example, if someone steals a lawnmower, they bring it to a pawn shop, they pawn it. They're looking at 3 felony charges. There's great case law out there for the defense that says you can't charge somebody with all those. It's really just 1 count. So just ask the court to take that into consideration because the charges inherently are a little duplicitous.
What was the problem yesterday where the division judge then remanded Mr. Pena?
Mr. Pena was remanded on the failure to appeal warrant in front of Judge Solomon, which is going to ultimately be his main issue, as well as the fact of when they cleared him for his arraignment bond status, he was cleared through division, but the new charges that were delayed in filing with new grand thefts, the new false verifications and the dealing in stolens, which all are older cases, it takes a while to investigate those cases. So when all those popped, that's why he was remanded and had to go back through the system, which is when all this stuff came to light. You follow me, Your Honor?
I'm trying to follow you. So counts 1 through 6 are grand theft, and they're all pending under case number 17008325 CF10.
Correct, and that's what he was. He was remanded yesterday, not remanded because the judge made him bondable. He was taken into custody to be processed on that case number, as well as 16309 MM20F. So the judge was required to serve those warrants. Now we have new charges that have all come up through processing him that ultimately would have been sealed until he was arrested. So those cases were active out there now, by him being processed through the jail. Cases that were previously not public record have now all been subsequently released and filed, is what I presume, because I didn't see those cases.
Mr. Linder, what's your recommendation as to a bond, as to the pawning and the dealing in stolen property charges?
Yes, Your Honor, I'm just gonna ask that the, excuse me, the convenience bonds be kept in place. In addition, one moment, Your Honor. In addition to the theft before Judge Solomon.
Well, one through 7 are staying where they are. That's the $1,000 on 1 through 6 and the $15,000 on 7. So it gives us $21,000 bond. Now we're dealing with the new charges of false ownership on the pawning and the dealing in stolen property.
Yes,
It
Your
looks
Honor.
like there are 2 counts generated on each transaction, if I'm interpreting it correctly.
One moment.
And Judge, if I just may, in my conversations with some surety agents, being able to collateralize things and my client's ability, if you made all the dealing in stolen counts $1,000, that puts a surety risk at $31,000, which is something that I believe I'll be able to provide the surety for. If you keep him at the $3,500, it's going to take him above his collateralization range. So that's where I'm at right now.
One moment, Your Honor.
Hopefully, Mr. Linder, because he doesn't get to see my joyful face, will agree with me.
Yeah. He's got a point there. I don't have an objection to that, Your Honor.
Okay, so counts 8, 9, 10, 11, 12 will be set at $1,000. Counts 13 through 17 will be changed from $3,500 to $1,000.
Judge, thank you so much for reaching out. I appreciate it. Thank you, sir.
Hold on one second. Mr. Pena, do you have any questions? Do not discuss the facts of your case. I'm sorry.
I have is for,
I'm sorry?
the only question I have is for Mr. Rydell.
Mr. Rydell, why don't you wait till he speaks to you directly, because everything here is being recorded.
We're working on getting you out, Sergio.
Not a problem. I have no further questions. Thank you, Your Honor.
Okay, thank you, Mr. Rydell. Thank you, Mr. Linder.
Judge,
Mr.
thank you
Pena,
so much.
have a
Stay
good day.
dry, all right?
You too. Bye.
Bye-bye.
I guess it is.
That's what we are. It's raining.
William Ruiz?
He's approaching, Judge. He's here at Maine. Come on up, Mr. Ruiz.
Mr. Ruiz, you have a new substantive charge, possession of heroin, possession of paraphernalia, and a warrant for delivery or a delivery of cocaine. I do find probable cause as to each count. Bond is set at $1,000, count 1, and the bond is set at $2,500. Have a good day, sir.
Judge, in speaking with Mr. Ruiz, he said he had an opportunity to speak with pretrial. He's 52 years old. He was living by himself, however. He moved into his mom with his mother. She's living in Miami Gardens. When he gets released, that's where he intends on residing to help her out. He's asking if Your Honor would consider releasing him on pretrial release.
Yeah, he also told us the story about living with the mother. The address that he gave us is different than the address that the mother says she lives. So we have some contradiction there, so we're not recommending him.
Thank you, counsel. Your request is considered and denied. The bond is $1,000, count 1, $2,500, count 3. Have a good day.
Yes, sir.
Jackelly Sharp.
No problem.
Mr. Sharp? Which facility is Mr. Sharp at? I'm sorry?
I believe North Broward.
Mr. Kelly Sharp?
Who calls? Who's that?
It's okay. Good afternoon.
Good afternoon.
Good afternoon, sir. You have a new substantive charge of DUI, count 2 aggravated fleeing, and count 3 driving while license suspended habitual.
Judge, in regard to count 2, the aggravated fleeing, I have a probable cause issue with that allegation.
As to what element, sir?
Well, there doesn't seem to be any aggravated fleeing. It looks like he's going 52 miles an hour.
What about the totality of the probable cause affidavit? Doesn't it indicate that there were 2 attempts to make a stop, and then the allegation is Mr. Sharp then drove off? The police then disengaged, not to engage in a high-speed chase, which to the level that it creates risk to the injury to the community. What I'm looking at is here is in the charge where it says with injury or damage. Is that a necessary element? I don't know.
That's what I'm pulling the statute,
I don't know that
Your
I
Honor.
saw injury or damage.
Well, that's what I was referring to primarily, is that there is no injury or damage.
At least none alleged.
Yeah, he didn't pull over, according to probable cause
So
affidavit,
let's
he
see-
didn't
let's
pull
see
over
what
when he
the
should
state's
have.
position is as far as the fleeing aspect of it.
Yes, Your Honor, and I'm reading from Florida Statute 316.1935, 3A. It states, any person who willfully flees or attempts to elude a law enforcement officer in an authorized law enforcement patrol vehicle with agency insignia, other jurisdictional markings, siren and lights activated, and during the course of the fleeing or attempted eluding, drives at high speed or in any manner which demonstrates a wanton disregard for the safety of persons or property, commits a felony of the 2nd degree.
Is that what's charged here? Because the printout is indicating with injury or damage. And I agree with Mr. Reedy. I'm not seeing that in the body of the probable cause affidavit.
Your Honor, what's charged here is 4A, which is also a 2nd degree. I guess what I'm saying is that, and the reason I read from that statute is the language that Your Honor used, which would seem to describe and satisfy 3A, which is still a 2nd degree. It's just a different elements are required.
So the state would be proceeding at this point for the purposes of first appearance at 316-1935 3A?
Yes, Your Honor, because
Mr. Reedy, you want to take a look at that statute?
No, I know the statute, Judge.
sorry.
I think it's certainly something this court can consider for bond. And I think the probable cause affidavit also goes on to say that he did stop at red lights. So when it comes to a fleeing, going 60 miles an hour down the road toward Flamingo Road, I mean, maybe that's a little fast. I don't know that it's necessarily a fleeing type of situation or an aggravated fleeing type of situation.
What do we have for Mr. Kelly Sharp as far as priors?
As far as priors, 2009, leaving the scene of an accident where there was injury, resisting without violence, and DWS, he violated his probation. 08, violation of pretrial release conditions, he violated his probation. 2008, battery and criminal mischief, he violated his probation. But additionally, Your Honor, from what I can tell, Mr. Sharp is currently out right now on charges of resisting without violence, drug paraphernalia, and threats to specified individuals. The allegations being that law enforcement attempted to conduct a traffic stop. Mr. Sharp continued driving. When he eventually stopped his car, he exited the vehicle and attempted to flee on foot. When he was arrested, it is alleged that, one moment, Your Honor.
Okay.
Well, I just want, when he was placed in the back of the officer's patrol car, he threatened he was going to kill the officer's children.
That was in that case, not this case, correct?
No. That was, I'm just, Your Honor, the reason I bring it up is because without going into detail, there are allegations that Mr. Sharp offered an explanation for why he didn't stop. And I think in light of the most recent arrest I mean, it's not a justified excuse to begin with, but I also think that it carries less weight considering he's shown a pattern of trying to fleeing or trying to flee from police.
Did I see something in here that Mr. Sharp had his daughter in the car?
Yes, he actually,
How old was his daughter? How old is it alleged his daughter was?
one moment, Your Honor. I don't know if it says her
Don't
age.
say anything.
And
I don't know that it says it. Okay. Anything else?
no, Judge.
I do find probable cause as to counts 1, 2, and 3. Anything else, Mr. Reedy?
Yes, Your Honor, Mr. Sharp has been living here in Florida for 15 years. He has family here, including his mother, his sister. He lives with his girlfriend. I've spoken with her. She's gonna try and come up with bond to try and get him out. They don't have a lot of money between the two of them right now. He also lives with his daughter. She's 15 years old. He went to and graduated from high school, and he's working 3 days a week. Right now, he was working at the Cheesecake Factory for 6 years, but he was recently laid off from that job. So as soon as he got laid off from Cheesecake Factory, he went out and found another job. So he's focusing attention on being gainfully employed at all times. But he doesn't seem to have a lot of money right now. I'd ask the court to take all those factors into consideration when setting an appropriate bond for Mr. Sharp. I think $1,000 bond on count 2 would be sufficient.
In consideration of the argument, the respective counsel, the applicable law, and the facts of the case, the court sets bond at $500 as to count 1.